Hey folks, I'm Greg McLawsen, the Affidavit of Support lawyer. I represent green card holders in federal litigation to enforce the USCIS Form I-864. I've represented these plaintiffs in federal litigation for about a decade now. But yesterday, we saw a federal court hand down an order that has gotten quite a lot of attention from immigration lawyers online and some forums that I'm in. And that is that a federal judge has awarded $256,000 in attorney fees for an affidavit of support lawsuit. $256,000, $250,000. That is to date the highest fee award that I am aware of in any affidavit of support litigation anywhere in the United States. I will say that I was one of the plaintiffs' counsel in this case, but my role was more limited in an advisory capacity. And the hard work in this case went to attorney Jody Winters, my colleague down in California, and his multi-attorney team who handled the case. I'm not going to go into the details of the case, but as to the question of how do we get legal fees that high in one of these cases, that's really no mystery. This is not the first affidavit of support enforcement case with fees over $100,000. We've seen those before in the Erler litigation, in the Dorsinio litigation. Both of those were federal court matters coming out of California. Both of them went up to the Ninth Circuit Court of Appeals and came down. How do you get there? Because affidavit of support litigation is to enforce the entitlement of the green card holder to a very modest amount of money. Damages under the affidavit of support, that refers to what somebody can get if they bring a lawsuit, are based on 125% of the federal poverty guideline. For a household of one, that's $1,400 per month. How in the world do you drive up $250,000 of attorney fees in order to enforce an obligation that boils down to $1,400 per month, just barely above the federal poverty guideline? Well, the bottom line is because federal litigation is expensive. If a party has to litigate a case all the way through the federal process, bringing the lawsuit, going through discovery, which is the formal exchange of information, motions practice, which is the process of narrowing down issues, seeing if you can resolve the case through trial, before trial, and then in the case of the high fee award cases, going to trial, that's a lot of legal work. In the affidavit of support and in the federal statute that underlies it, there is an attorney fee provision. And under that provision, if a plaintiff, which is a green card holder, has to bring a lawsuit to enforce her rights under the affidavit of support, and she prevails, she's entitled to her attorney fees. And that fee award does not depend on the amount recovered in litigation. As a practical matter, the amount that's recovered is always, so the damages at issue are almost always going to be less than the attorney fees. But Congress put that provision into the statute because if it wasn't there, no sponsored immigrant could ever afford to defend their rights under the affidavit. Because if I'm a green card holder who's unemployed, often these are domestic abuse survivors, and I want to enforce my right to financial support of $1,400 per month, I can't pay a 3-person legal team or one lawyer to go litigate a federal case. I can't pay that because I can't even pay my own bills and put groceries on the table. That's why I need $1,400 a month in financial support. Well, if there wasn't an attorney fee provision in the statute, all a defendant would ever have to do is throw a whole bunch of money at litigation, make it really expensive for the plaintiff to bring her case, and she would just throw up her hands because she would say, I can't afford to do that. But because there is a fee provision, and because, as we saw yesterday, judges will give that provision of the statute full and appropriate effect, if a sponsor tries to evade their obligation under the Affidavit of Support and forces a plaintiff to push her case, and she prevails, she's entitled to all of the expenses that it took to make that enforcement case successful. What do we take away from this? What sponsors and their attorneys should take away is that energy needs to be spent on getting early stage fair resolutions in these matters. And if you're taking this to the mat and you want to have a throwdown legal battle and you lose, what you are going to be left with is something like what we saw yesterday, which is an extraordinarily high legal bill. There is case law out there, and it is well established now, that sponsors have no affirmative defenses to liability under the Affidavit of Support. What does that mean? Standard contract law defenses don't apply. The defense of fraud doesn't apply. But I still see often attorneys who want to spend resources of their client. The attorney isn't paying for this, but I see defense attorneys spending their client's money to go to court and argue about whether these defenses apply, even though every federal court to consider it has said that they don't. Well, if you spend the plaintiff's resources to relitigate something like that that's already been established, and the plaintiff has to go and prove yet again that defenses don't apply in these cases, that's money that the defendant is going to be paying to the plaintiff and her legal team. Money that could have been spent just going to the table, the negotiating table, and penciling out a fair resolution of the case early in the process. A lot of my colleagues, it seems like, are sick of hearing me say that people just need to spend their resources, coming to the table and figuring out a fair deal, because that is so much less expensive than spending resources like we saw in this recent court order, paying attorneys to go fight about $1,400 per month in federal court. So when I see an order like the one that was handed down yesterday, it's just a reminder that, yes, you can use the federal legal system to enforce the Affidavit of Support for sure. But, in a sense, it's a big failure on the part of the attorneys to come together and work cooperatively to reach an agreement that avoids that sort of high caliber litigation, because all of the resources that go into that litigation could just as well have been spent early on to get the plaintiff the very, very modest amount of support that they are entitled to under the affidavits. A lot of times sponsors want to argue, is my liability $14,000 or is it $12,000? And so they want to fight as a matter of principle that it was 12 and not 14. It's so much the wiser choice for the parties, and it's usually both of the parties, to just split some of the difference in terms of how they calculate damages under the affidavit, come up with a figure that maybe isn't what either party wants, but is close enough that they can both live with. That's what federal judges tell my clients every time we go into a mediation. In settlements, neither party gets 100% what they want. There is some give and take on both sides, and that is absolutely the case in Affidavit of Support litigation. It's true of my clients that I represent. We don't get everything that we want in settlement talks. That's just the reality. But both parties are better off going that route. Sponsors are going to pay more than they want in damages, but oftentimes they are going to pay less than they will if they reject all settlement, blow it up, go to trial, and get something like what we had yesterday. Likewise, the plaintiffs may end up getting less than they want, but they're going to get it a lot faster than if they go through months and potentially years of litigation. So again, high attorney fee awards in these cases, in a real sense, represent a failure of the process, in the sense that everybody would have been better off if a resolution had been voluntarily reached early on. But it's also a success and shows the system working properly, because that fee provision in the statute exists specifically so that green card holders have real rights under the Affidavit of Support. Because again, if they had to pay their own way in litigation, they could never afford it, and defendants could always evade their obligations and their liability under the affidavit simply by throwing money at litigation. And what we've seen yet again is no, that's not going to work. And if plaintiffs go the distance in these lawsuits and effectively prosecute their case, those costs are going to come out of the pocket of the defendant. So take home message again, play nice, come to the table, work out settlements, be cooperative. I will give another shout out to one of the best defense attorneys in the country, Van Doan, who reached a settlement with me in a very challenging case this week. And that's a success for everybody involved. Everybody there, all the attorneys and the clients, worked hard to reach an agreement that was acceptable to everybody. And so there's an example right there of an attorney doing good by her client, getting a result that's acceptable to everybody, and avoiding tens of thousands, or as we've seen, potentially hundreds of thousands of dollars in legal fees. Have a good week, everybody. Happy Friday. Have a good weekend. If you have questions about the Affidavit of Support, drop them into the comments. If you are a green card holder who would like an individualized case assessment of your potential rights under the Affidavit of Support, reach out to me on our website. We do free video consultations all across the United States. Have a good weekend, everyone.